Okay, I got a message that it was being live streamed. Yep, we're on. All right. Good morning, everyone. For those who are joining in on the YouTube streaming, I got a message that it was being live streamed. Yep, we're on. Yes. Okay. Thank you. And for those who are not speaking, please put your mics on mute because it interferes with hearing what people are saying. So let me introduce myself again. My name is Salvatore Giorlandino. I am the Chief Presiding Officer of MassDEP's Office of Appeals and Dispute Resolution. The Appeals Office is responsible for advising MassDEP's Commissioner in the resolution of all administrative appeals filed with the Appeals Office challenging a permit decision, a MassDEP permit decision, or enforcement order. The Appeals Office is a quasi-judicial body that's staffed by 3 senior environmental attorneys, including myself, who are presiding officers. We're quasi-judicial officers. We are independent from the Office of General Counsel, MassDEP's Office of General Counsel, independent from all the programs at DEP, including the Wetlands Program and the Chapter 91 program, to name a few. The Appeals Office reports to the Department's Commissioner. What's scheduled for this morning is a pre-hearing conference in a wetlands permit appeal that has been brought by a group calling itself the East Boston Residents Group that is, according to the appeal notice that was filed, consists of about 25 individuals who live in East Boston who object to or have appealed challenging a superseding order of conditions that MassDEP's Office of Appeals and Dispute Resolution, an SOC that MassDEP's Northeast Regional Office, getting my offices confused this morning, my apologies, that the Northeast Office issued pursuant to the Wetlands Protection Act and the Wetlands Regulations, authorizing a proposed project by NSTAR/Eversource to construct an electric substation with 2 underground electric transmission cables on 400 Condor Street in East Boston. And according to the residents group, DEP's approval through this superseding order of conditions, or SOC, as what is the common acronym for a superseding order of conditions, is improper for 2 reasons. One, that the DEP issued it in violation of the Wetlands Protection Act and the Wetlands Regulations, and in violation of the environmental justice policy of the Executive Office of Environmental Affairs, acronym is EEA, that all agencies under EEA's jurisdiction, including MassDEP, are required to adhere to. And so the purpose of today's pre-hearing conference is not only for me to get a sense of who is in this appeal, who's participating in this appeal, to establish the issues for adjudication in the appeal, and to establish the schedule for the parties to file pre-filed testimony, sworn pre-filed testimony from their respective witnesses in support of their respective positions on the issues for adjudication in the appeal. For those of you at this pre-hearing conference who are not familiar with the adjudicatory process that MassDEP's Appeals Office utilizes, it is a trial court type process. It is a process that comes closest to a trial court proceeding. It's a quasi-judicial proceeding with one big difference, is that we have a system of sworn pre-filed testimony that is filed before the evidentiary adjudicatory hearing. And the evidentiary adjudicatory hearing, which I'll call hearing for short, is the trial of the appeal regarding the issues for adjudication in the appeal. And the parties' respective witnesses who have filed pre-filed testimony prior to the hearing, according to the schedule that I will establish, are expected to appear for cross-examination on their pre-filed testimony. In other words, everyone going into a hearing is supposed to know what theirs and their opponents' respective positions are. And then the hearing is a cross-examination exercise where opposing parties get to cross-examine the witnesses for the opposing parties. Does everybody understand that? Mr. O'Brien, do you understand that as the group representative?
Yes, thank you for that clear explanation.
Yes, you're welcome. And, you know, and so for that's why I issued, as I do in every appeal, unless an appeal is defective on its face, a scheduling order that requires the parties to the appeal to attend a pre-hearing conference, and that the scheduling order also schedules a hearing date in advance, way in advance in the future, so that people know up front that if the matter or appeal is not resolved, that it will go to a hearing, unless it's disposed of because of a failure to file pre-filed testimony by the appellant, or that the testimony that was filed is so woefully inadequate that a hearing would not be necessary to conduct. And so that's why I issued a scheduling order on January 31st, setting forth the pre-hearing conference for today, and scheduling the hearing, I believe, in May of some time. Actually, the hearing date in May is May 18th. Excuse me, stand corrected. Now, Mr. O'Brien, I do not want to come off as being annoyed, but I will tell you that scheduling orders, like any other order I issue in this appeal, is a serious thing to follow. And that if there's any issue with complying with it, like complying with a deadline, that it's important to make that known to me before the deadline expires. I will tell you, and I plan not to make an issue of it, because I will take you at your word that the group will comply with future timelines and orders that I issue in the case. But my scheduling order did require the group, the residents group, to file their pre-hearing statement last Friday. That was the deadline. And there was no request for an extension of time to explain, why it couldn't be filed then. And so I received it, the group filed it last night at 4:30. And that was about 5 hours after the applicant, NSTAR Eversource, filed its pre-hearing statement, and about almost, Mr. Fallon, correct me, about 3 hours after DEP filed its. And so from I use the word fairness. There have been, allegations in the residents group's appeal notice that the group hasn't been treated fairly with respect to issuance of the SOC here. So my point is, everyone has to follow the rules. And the other thing that the group needs to do, and I'm going to require it, I'm going to accept the pre-hearing statement that the residents group filed last night under the condition that by Friday, there's a signature page, because every document that's filed in an appeal has to be signed either by the attorney representing the party in the appeal, and if it's a citizens group, residents group proceeding like this one, and they're proceeding without an attorney, the residents group representative, and it has to be signed because there is a specific adjudicatory proceeding rule, 310 CMR 1014, B, I believe, that requires everything to be signed. And the signature is basically, it says in the rule, you can look it up, that the signature on the document is a certification that the signer believes that the contents of the document are true and that the matter hasn't been brought for purposes of delay. I am not suggesting at all that the residence group appeal that has been brought in this case is frivolous. Not at all. I have made no determination, and I have nothing to lead me to believe that way. However, the unfortunate reality is, Mr. O'Brien, that the appeals office does receive frivolous appeals. And I think everyone on this call would agree that a frivolous appeal does not further the noble cause of environmental protection. And so, Mr. O'Brien, is what I said been clear? Do you understand? Does the group understand?
Yes, I understand. These points are very well taken, and we do apologize to the officer as well as to the other parties for our lapse in procedure, and we'll make every effort to comply as you described.
That's right. And like I said earlier, Mr. O'Brien, the rule about asking for an extension of time applies to everybody, okay? And I generally grant extensions of time unless there is some real compelling reason not to. But I just wanted to let you know that it was important for me to make note of that information at the beginning. And so now I want to get down to the business of the appeal. I know Mr. Fogel in the applicant's pre-hearing statement indicated that the group had not initiated settlement discussions with the applicant and with DEP. That's an important feature that or requirement, excuse me, that should be followed. I'm not going to get into now the reasons why the group did not contact Mr. Fogel and Mr. Fallon to discuss potential settlement. But I would advise that there's no harm in having that discussion after this pre-hearing conference, not on this call, but schedule a time where you can speak to Mr. Fogel and Mr. Fallon. I'm not saying that to browbeat anyone into a settlement, but as a result of what you hear today regarding the issues for adjudication and the schedule, it might be something that you want to have a conversation, but I believe it's important to have that conversation. Mr. Fogel, Mr. Fallon, do you disagree?
No, the department doesn't.
No, don't disagree with that. We were not contacted. I understood you to say that you wanted the petitioner group to file something by Friday with the signature.
Yes, the signature. I want a signed document.
I'd like, in that regard, I'd like to have the contact made before Friday so that at least they can report on the conversation we might have before that time.
Sure, that is fine. And Mr. O'Brien, if you can follow up with Mr. Fogel and Mr. Fallon on that request, that would be great.
We'll do that promptly. Thank you.
Sure. So now let me get to basically the business of the appeal, and that's the issues for adjudication and the schedule. When I say schedule, it's the appeal adjudication schedule. All right. And before I get into that, let me just state that this, unless there is some reason it won't go to a hearing, this matter will go to a hearing if it's by agreement of the parties. And like I said, my philosophy on settlement is I don't pressure anyone into settling. That's their choice. So long as the parties understand that if it does go to a hearing, there will be a recommended final decision from me, and that someone will prevail. Actually, the person who ultimately decides who prevails is the commissioner. Because what the presiding officers do, they conduct the hearing, they hear the witnesses testify, and based on the testimonial and documentary evidence that's introduced at the hearing, the presiding officer issues a recommended final decision that the commissioner reviews, and the commissioner's authority is to adopt, modify, reject what the presiding officer has submitted by way of a recommended final decision, or order a new hearing if the circumstances warrant it. I will tell you that in 15 years of being the department's chief presiding officer, I'm in a position to state that the 5 commissioners I've worked for have basically affirmed us the vast majority of the time. And I don't say that to brag or gloat. It's a good thing that that's happens, because there would be a problem if you had a high reversal rate. There'd be some inquiry. I only mention it because of, a presiding officer who hears a case similar to a trial court judge, has seen the witnesses, has heard the witnesses testified, has reviewed the evidence, and so is in a position to opine what's valid and what's not. That doesn't mean the commissioner doesn't have the authority to do an independent review. Commissioner Martin Suberg, I can tell you, he is a lawyer and he has had various roles in this office, meaning DEP, and he is someone who takes, like every other commissioner, his role on issuing final decisions in appeals very seriously. So that's, by way of introduction, what I think the issues for adjudication in this appeal, after having read the resident group's appeals notice. Mr. Fowler, do you want to say something?
No, I'm sorry.
Okay. No, I saw on my screen either a hand go up or whatever I may have imagined it saying. So.
Oh, no, I apologize if I hit it. I'll keep my hands away from the keyboard.
Okay, thank you. But what I was saying with respect to the issues for adjudication in the appeal, as a result of reviewing the resident group's appeal notice, the resident group's pre-hearing statement, and the pre-hearing statements that the applicant and DEP have filed, I have a sense of what the issues should be for adjudication. And before I state what I believe those issues are, just by way of reminder that the residents group, as the party who brought this appeal, has the burden of proof on all the issues of adjudication. And that the residents group, this matter goes to a hearing. Like I said, right now it looks like it is, but we don't know what happens down the road. That the residents group will have to present competent, credible testimony in support of the group's claims that the department issued this superseding order of conditions in violation of the Wetlands Protection Act and the wetlands regulations, and in violation of the EJ policy. That's the burden of proof. And it has to be done through the testimony and documentary evidence that the group submits. And so with that being said, I believe there are 2 basically broad categories of issues for adjudication. The first one is the obvious one. And everything I say today, by the way, Mr. O'Brien, it will be confirmed in a post-hearing conference report and order and appeal adjudication schedule. So all the issues for adjudication that I'm saying verbally today in the pre-hearing conference, the schedule for filing pre-file testimony that I will be telling the parties today, including yourself, when the deadlines for filing pre-filed testimony, that will also be in my post pre-hearing conference report and orders and appeal adjudication schedule. Do you understand thus far what I've said, Mr. O'Brien?
Yes, thank you.
Sure. And so with that being said, the issues for adjudication on which the residents group has the burden of proof, two broad categories. The first category is like I said, the obvious one. Did Mass DEP properly approve the proposed project pursuant to the Mass Wetlands Protection Act and the wetlands regulations? That's the broad question number one, right? And then under that question, I have 6 sub-questions. And this is based on also my review of the superseding order of conditions. I apologize for not having said that in addition to the appeal notice and the pre-hearing statements, I also read the superseding order of conditions that Mass DEP's Northeast Regional Office issued, okay? And those 6 sub-questions under that broad category, was it issued properly pursuant to the Wetlands Protection Act and the regulation? A, Mass DEP properly determined that the proposed project will not impact Coastal Bank? B, did Mass DEP properly determine that no portion of the proposed project will be located within any area of land subject to coastal storm flowage? C, did Mass DEP properly determine that no portion of the proposed project will be located within any area of coastal beach? D, did Mass DEP properly determine that no portion of the proposed project will be located within any area of riverfront area? E, did Mass DEP properly determine that no portion of the proposed project will be located within any area of bordering land subject to flooding? And F, did Mass DEP properly determine under its plan change policy that the changes for the proposed project as set forth in the applicant's revised project plans were not substantial changes requiring the filing of an NOI? Now, Mr. Fogel and Mr. Fallon, I realize that the SOC that was issued said that with respect to land subject to coastal storm flowage, coastal beach, riverfront area, bordering land subject to flooding, that those are not impacted, or not, that the proposed project would not be located in any of those areas. I just want you to know that I'm aware of that. But because this SOC has been challenged, I think that should be addressed. And I believe if the applicants and the department's position is through their expert witnesses that those areas weren't impacted or not part of the proposed project, that's all that's required. So I just want to say that up front, because of, like I said, I went through the SOC as well as the pre-hearing statements and came up what I believe to be the issues for adjudication regarding the broad category number 1, okay? Mr. O'Brien, Mr. Fogel, yes?
No, at the appropriate time, I'd like to speak to that, but if you have a question for Mr. O'Brien, I can wait.
No, well, I'll go to him. I can address it now. Yep.
My concern is that the issues you just identified haven't ever been identified by the petitioners. They didn't raise it in their appeal and they didn't raise it in their statement. And frankly, after looking at the petitioner's statement that came in late yesterday, the applicant's position actually is that there are no factual issues in dispute, and that the issues regarding the plan change policy and the EJ policy are legal issues and may be able to be addressed by appropriate motions or pleadings. So I just would like to respectfully push back and urge the presiding officer to determine that there actually are no factual issues in dispute. Nothing about the jurisdictional buffer zone of Coastal Bank has ever been addressed in any manner in this proceeding by the petitioners.
Thank you for that position. I'll hear from Mr. Fallon if the department has any opinion on that.
Thank you, Officer Gerlandino. The department basically agrees in reading the petitioner's notice of appeal and and in our interactions with the petitioners during the site visit, the real issues we think the petitioners are concerned with have to do with the proper application of the EJ policy, which is a concern we understand because this project is located in an EJ neighborhood, and the plan change policy, which we think both are legal issues that could be addressed by summary decision. The question of these other resource areas, I understand why the presiding officer sees that, because there are things that are referenced in the SOC, and they are tangentially referenced in the appeal documents as concerns that the citizens brought up. But the real thing that we would like to express to the citizens group, we do want to hear from them. We want to hear their concerns, but our jurisdiction in this project is limited to buffer zone to a coastal bank that's not even on the site, and that we did consider implications to their neighborhood. We would do that anyway, regardless of the status of an EJ neighborhood, but in particular, because it is an EJ neighborhood, we consider the special circumstance around it, and we don't see an issue that would involve any health impact or environmental impact to the EJ neighborhood as a result of the work proposed in buffer zone to the coastal bank. So if those particular resource areas are to stay at issue, I think they would be, they could be properly addressed through a summary decision motion. And if at the end of summary decision, it's decided there are fact issues remaining, whether those resource areas are present or not, then we could always go to hearing. But I do see the concerns of the citizens group really relating to legal matters, in particular, the proper application of the EJ policy.
Thank you, Mr. Fallon. Mr. O'Brien, do you want to weigh in to what Mr. Fogel and Mr. Fallon said?
Yeah, we basically agree with the notion that the real thing under review here is the procedural questions, right? The environmental justice, whether or not there's substantial changes. In terms of, but at the same time, I'm a little apprehensive about agreeing to a summary judgment, a summary process. We would like to have a hearing. I think that's very important. If the hearing officer independently identifies things that we didn't raise or raised tangentially, would certainly welcome that too, based upon the best judgment. I also do want to point out, and this was not specifically mentioned, but we raised the point, I think the residents in both the notice and in the paper filed, is that the underlying City of Boston Conservation Commission, the NOI, didn't address the question of other related permits and approvals, which is a very important point in this particular project. And I'm not entirely sure of how the department complies with that, but there is the very important question which we'd like to see acknowledged and put out there in the proceedings, which is how the very specific Wetlands Act review relates to all the other Chapter 91 and related matters, which were not set forth, certainly in the Conservation Commission and not so much in the DEP either. Thank you.
With respect to the other permit approvals, Mr. Fogel, Mr. Fallon, I believe General Condition 3 has a provision. It states that other approvals are necessary. So I don't know. I'm not making a decision or judgment on any local approvals, but the fact is, if there are any other local approvals, General Condition 3 would take care of that, wouldn't it? Yeah, Mr. Fogel.
Well, I think what Mr. O'Brien might be referring to is the petitioners have somewhere along the line raised the issue of whether the condition was met, the requirement was met to obtain or apply for all obtainable local permits, variances and the like. And that condition was met, that requirement was met. And I think Ms. Blaine can speak to that. It had to do with the project obtained as complete zoning exemption from the DPU Energy Facility Siting Board as part of its approval. So I think that's it's a tangential legal issue that the petitioners have raised that had more to do with that requirement of the completeness of an NOI and the timing of being heard before the Conservation Commission. But I think that issue's long gone, if you will. I would also just quickly like to say that in response to Mr. O'Brien's comment that they would, like to be heard, that they certainly would have an opportunity to be heard during any argument, if you were to hold oral argument on any motions regarding the legal issues. But the applicant still believes strongly that this case doesn't need or justify a evidentiary hearing on any factual issues. Thank you.
Mr. Fallon, as to my question on general condition 3.
Yes, general condition 3 does address all obtainable permits from the department's perspective. That typically is done at the time of the filing of the notice of intent. The Conservation Commission is the agency that is on the ground and knows the local requirements that an applicant needs to go through in order to satisfy those requirements. Typically, and I think our case law is pretty consistent on that issue, unless there is some glaring omission. That's something that is addressed at the local level before the Conservation Commission.
Mr. O'Brien, Mr. Fogel and Mr. Fallon are absolutely correct with respect to their positions on the local approvals. I understand, the group's desire to raise that issue here, but that's a pretty straightforward issue that has been addressed previously in other appeals. It's generally well settled, established environmental administrative law that what Mr. Fogel and Mr. Fallon said is the case. And so what I want to do is just focus on, the issue of whether the broad issue of whether the SOC complies with the Wetlands Protection Act and wetlands regulations. Mr. Fallon and Mr. Fogel, I hear you regarding your respective positions about, well, this really isn't a complicated case, could be resolved potentially in summary decision. But I believe the proper course, because the petitioners have the burden of proof, is to lay out the issues the way they are. Because if the determination was that the proposed project is not going to be located in any area of, those wetlands resource areas that I mentioned, land subject to coastal storm flowage, coastal beach, riverfront area, bordering land subject, then the petitioners have to present expert evidence. And was Professor Luna, Mr. O'Brien, is Professor Luna going to be your expert witness on all issues?
Yes, thank you. He's very familiar with the case, having participated for quite a number of years on this. And yes, he's going to be our expert.
And he has a very distinguished background, and he seems to have expertise in various areas. But is he an expert on wetlands regulation?
At the moment, I can't speak to his expertise or lack thereof on regulation.
Because the appeal, you need, like I said before, if on all issues for adjudication, the petitioners need to have competent, credible testimony, and the person testifying has to be able to opine on the subject matter at issue. Going back to Mr. Fogel and Mr. Fallon, one of the reasons also I am inclined to have the broad wetlands adjudication issue framed the way I proposed it was because of the opportunity of directed decision. That after the petitioners file their materials, if the applicant and or the department believe that it is not appropriate for both the applicant and the department to expend resources to brief issues that the petitioners basically did not address and have essentially waived, there's that opportunity to do it. And then we can winnow it down, so to speak, or narrow it down. Yep, Mr. Fogel.
I appreciate that opportunity, but I just want to say one last time, if I could, that I think you're creating an issue that the petitioners themselves didn't even raise. I mean, they were present on the site walk.
Yep.
And for the SOC, and never raised during that site walk whether there were any resource areas other than the buffer zone to coastal bank. So I just think we're creating a process for something that even the petitioners haven't raised themselves.
Mr. Fallon?
Excuse me, thank you.
Yeah, but, as I said, there's the opportunity for directed decision. And as you are aware of, in 2 recent cases, I certainly looked at the directed decision vehicle and made orders subsequent. And you know the 2 cases I'm talking about.
Yes, I do. Thank you. Thank you. Yeah, the directed decision, if that is a rule and then it works, I think it's a valuable rule. I do agree with the applicant that these were not identified resource areas, but to the extent if the department missed something and there's an expert that'll come forward and tell us we missed a resource area, that is something we would have to consider. I think we're comfortable that the only resource area here is buffer zone to coastal bank. And this site has been examined extremely closely by the department and other agencies. So I would be surprised if there's a resource area that we missed. But I would just throw out another pitch for a summary decision could be a tool, but I think that would still require the petitioners to come up with an expert to identify the resource areas.
Right. And where I'm coming from, Mr. Fallon and Mr. Fogel and Mr. O'Brien, also that this is a de novo proceeding. We start anew. And yes, the department has made its determinations and I'm not bound by them. I can, inquire. And I believe doing it this way, and Mr. O'Brien, I'm going to have you confirm again for the record that you understand you need expert testimony. That with respect to those issues I just outlined, if you don't have the expert testimony, there's a motion from the applicant and/or the department on directed decision saying we shouldn't be required. When I say we, the applicant and the department shouldn't be required to address in pre-file testimony and in pre-hearing memoranda on issues that the group has not addressed by way of pre-file testimony. I'll let you know up front that I would be inclined to grant such a motion. Okay. And so, on the wetland, so did you have something to say, Mr. O'Brien? I didn't mean to cut you off.
Very briefly, yes. The procedure outlined totally makes sense. We're okay with the directed decision approach as long as we have opportunity to, in our subsequent filings, to raise the issues, and we'll make every effort to get an expert should we think that's helpful.
And Mr. Fallon, I don't want to use a quote against you, but I've heard you say it in 15 years of me being chief presiding officer, that the department always keeps the door open to make it a better permit.
That's very true. Thank you. Yes.
That's right. You have said that on many occasions, and I don't do that to basically tease you or disrespect you, but my line of thinking is precisely along those lines as well.
Thank you. Thank you. Yes.
Yes. All right. And so that takes care of the broad issue regarding wetlands. With respect to the second broad issue, does the approval of the proposed project comport with EA's 2021 EJ policy? I think everyone agrees that the East Boston community where this proposed project would be located is an environmental justice community. Now, for my education, is the community, does it fall under all 3, low income, minority, and English isolated? Because that wasn't clear, although I know it's in East Boston, that East Boston is an EJ community. it wasn't clear to me which categories, which facets of EJ community. Is it all three that I just mentioned, or one of them, or two of them?
Yes, I believe it's all three. Mapped as
All three? That's
Yes.
what I thought. That's what I thought based on my own independent knowledge of East Boston. And so it's undisputed that it's an EJ community. The EA policy clearly requires that environmental justice principles be part of the integral part of the regulatory work that the department does for all programs. And so I'm just curious, Mr. O'Brien, because I had, it wasn't clear to me, what specifically did DEP purportedly do wrong in violating in the group's contention that it violated the EJ policy? Can you flesh that out for me?
Sure.
And I assume Mr. Fogel and Mr. Fallon, you would want that explanation as well. I don't want to assume, but I want to ask you first.
Yes, that would be helpful.
Yes, yeah. So, Mr. Bryan, if you could flesh that out for me.
Sure.
Why does the residents group believe that DEP's approval of the proposed project violates the EJ policy? Why is that?
Yes, thank you. So preliminarily, if it's agreed and acknowledged that East Boston is an environmental justice community,
That is correct.
that brings into play a whole series of considerations regarding not just the particular impacts of the project, but also the historic cumulative impacts. And it's a relatively new policy. It's still evolving. Its application to particular projects is still being worked out. The position quite consistently from the East Boston residents' point of view, including appellants, is that the proposed project both harms jurisdictional resources under the Wetlands Act, but also is part of a cumulative set of impacts along jurisdictional resources that adversely harms residents as well as protected jurisdictional resources. Now, we'll look forward to fleshing that out in the papers that we file.
Yep.
And
Well,
in the expert testimony.
and perhaps I will insist in that endeavor and basically framing what those issues are, because we need to narrow. Because I am giving the residents group some leeway here regarding the EJ claim. Let me just state, EJ considerations are very important. They have to be followed or adhered to. So I don't want you to interpret that anything I'm saying is an insensitivity to EJ. But if an EJ claim is made, like any other claim, it has to be proven. And during the past year, when I have applied the most recent policy, which is the 2021 EA-EJ policy, and I am not convinced yet I'm going to do this, but the way I like to frame whether or not the approval being challenged violates the policy is to include, among other things, review the guidance that Mr. Fallon submitted. I believe you did, Mr. Fallon, as an exhibit or as a separate document with the department's pre-hearing memo. I believe you did.
Yes, I did.
Yeah, because I know I read it for this, and I believe it was. And so there are categories of permits that fall under that guidance, which now the residents group, if it didn't have before, now has in its possession. And this type of permit is not specifically included. However, there is language in the section that I'm referring to that gives the department discretion to include other permits if the circumstances are warranted, okay? And with that, that's one thing. And then, if you read the EA's 2021 EJ policy, it talks about environmental benefits and environmental burdens. And clearly there is those provisions in the policy, which I am very familiar with, regarding whether a proposed project will discriminate intentionally or by disparate impact on any persons because of their race, color, income, class, handicap, gender, identity, sexual orientation, national origin, ethnicity, ancestry, religious belief, or English language proficiency. If I am reading this correctly, the group's position, you're not asserting that. What you're asserting, because I heard you say cumulative, okay? Impacts, that's what I heard you say. Am I right, Mr. O'Brien?
Individual and cumulative, both, yes.
That's right, individual and cumulative, but the key word is cumulative, right? Am I right? Okay, and so that in my mind goes to two questions. And the first one is, will the proposed project provide environmental benefits? And if so, what are those environmental benefits and how will they be equitably distributed? I'm just going by what the policy says about what environmental justice principles, what they're defined as. And I'll flesh this out in my post pre-hearing conference report in order to let you know where I'm coming from on it. And then the other question is, will the proposed project cause environmental burdens? And if so, what are the environmental burdens and will they be equitably distributed? And so I did read, I believe both Mr. Fogel and Mr. Fallon in their respective pre-hearing statements made mention of the applicants and the department's respective positions that this project is not going to have any kind of adverse environmental impact. Am I right, Mr. Fogel and Mr. Fallon? That was said either as in passing or part of your pre-hearing statements?
That's correct for the department.
Yeah.
And to be clear, in the context of this wetland appeal, it's specific to the issue of adverse impacts on wetland resources.
That's correct. That is correct, because we are dealing with, if this was an air permit, then we'd be talking air permit requirements and what impact proposed facility governed by air permit regulations. But this is wetlands. So whatever, when it comes to environmental benefits and burdens, we're talking wetlands, all right? Because the EJ policy, by its terms, requires DEP, when administering all its environmental programs, including the wetlands program, to make EJ an integral part, and therefore it's wetlands. Mr. Fogel, thank you for raising that important issue, because I think that was an important clarification, that we're dealing with wetlands.
Could I add to that, just for your understanding of this, that one of the things I want hopefully to head off during this proceeding is for the petitioners to try to bring in the issues that they raised with the Conservation Commission that are germane only to the Boston wetland ordinance.
Yeah.
There are, climate change and the like, sea level rise. Those issues were all litigated in front of the Conservation Commission, and during the petitioner's separate certiorari appeal of the local portion of the order, which, by the way, the Superior Court dismissed for lack of standing.
Okay.
So I want to encourage you to keep in mind, if I can, that when you say wetlands issues, that hopefully you will limit it to the wetlands issues that you mentioned earlier that are germane to the Wetlands Protection Act and the state regulations, and it won't get expanded, if you will, by the petitioners into the other issues that were raised only under the ordinance.
Thank you, Mr. Fogel. Mr. O'Brien?
Yeah, we're very mindful of that. We're not introducing local ordinance issues here.
Okay.
However, the point on we're talking wetlands is very important. We're talking individual and cumulative impacts on jurisdictional resources within the context of environmental justice. Yes, that's our thrust of this section of the appeal.
Yep. And that's why as I said before, and Mr. Fallon, before I talk, I'm sorry for not turning to you if you wanted to weigh in on what Mr. Fogel just said.
No, I appreciate the chance to weigh in. And I think everyone is in agreement on this, but we do get sometimes confusion on with a wetland permit that siting could be an issue. Siting is not an issue for the project. We are only going to discuss impacts to wetland resource areas in the
Right.
context of environmental justice.
Exactly. And Mr. O'Brien, I think you agree with Mr. Fogel and with Mr. Fallon and with me that, you know, the EJ inquiry will be limited to the individual and cumulative impacts to wetlands resources
Yeah,
that
and-
are an issue in this case. We're not going to go beyond what is at issue. And you're going to need an expert wetlands expert to testify. And like I indicated earlier, Professor Luna has a distinguished background, and if you say that he'll be able to testify on wetlands issues, I assume he'll be testifying on EJ issues because his background, to me, he has a long history, academic history, professional history in the EJ area, from what I understand. He's done good work, but you know, like any other witness, he has to have the ability to opine on the subject matter at hand. So, you know, I think you've heard me that with respect to the EJ issue, it's going to be those two questions about environmental benefits and environmental burdens. As I, you know, and I'll just reiterate them again, saying, you know, will the proposed project provide environmental benefits? And if so, what are the environmental benefits and will they be equitably distributed? And then the next question, does the project cause environmental burdens? And if so, what are the environmental burdens and will they be equitably distributed? That's how that EJ question will be framed. And it's going to be limited, like we've just talked about, to wetlands issues, because that's what this is. This is a wetlands permit appeal with an EJ component, because the wetlands program, like all the other programs at DEP, have to be administered in accordance with the EJ policy. And so that's what I have for issues for adjudication. Unless anybody has any questions about the issues for adjudication, I want to go next to the schedule for the parties to file pre-file testimony and memorandum of law, pre-hearing memorandum of law on the issues for adjudication. And so, Mr. O'Brien, as I indicated, the petitioner, the group, you know, the residence group. When you hear me say petition, that means the petitioner. That means the residence group, because it was the residence group who petitioned or brought this appeal. Okay, and so the residence group as petitioner has the burden of proof, and as such, the petitioner is required to file its pre-filed testimony. The group is required to file the pre-filed testimony of its witnesses first, along with their pre-hearing memo on the issues for adjudication. And the deadline for that would be about a month from now, March 23rd. And all these deadlines, like I said, are going to be part of my post pre-hearing conference orders and appeal adjudication schedule. All right. And then on April 20th, it would be the applicant's pre-filed testimony and memorandum of law. And then on April 27th, it would be DEP's pre-filed testimony and pre-hearing memorandum of law.
Pardon me, what was the first date for the petition?
The first date, March 23rd for the petitioners.
Thank you.
That's their deadline, pre-filed testimony, pre-hearing memorandum of law. Then the applicant, April 20th, and then DEP a week later. And Mr. Fallon, in keeping with past practice, and to avoid repetition, as I think we have been very successful thus far in administrative appeals, when Ms. Provencal reviews the pre-file testimony and let's say she's reviewing the applicants because the applicant and the department are aligned in this appeal with respect to requesting affirmance of the SOC. Ms. Provencal agrees with what the applicant has to say, what the applicant's witness has to say. She can simply adopt it as her own or add more information. I will leave that to you folks, to decide what to do. But that's just by way of past practice to avoid, repetition. And it's worked well. So just wanted to confirm that. So are we all on board on that? That's fine. And then Mr. O'Brien, after DEP files its materials, the petitioner would have the opportunity to file rebuttal pre-file testimony from their witnesses, limited to what was said by the applicant and DEP. Can't raise anything new, strictly limited. That's what rebuttal testimony means, is that you're rebutting what they said. And you're not required to file it. You may, unlike your first deadline of March 23rd for your pre-file testimony, that's your direct pre-file testimony on the issues for adjudication. And the rebuttal is discretionary on your part. You decide whether or not you want to file it. But if you do decide you want to file it, May 11th would be your deadline to do it. Okay. And then we still have the hearing scheduled for May 18th. I'm not changing that. And as I indicated earlier, Mr. O'Brien, I mentioned the directed decision option, and that is up to Mr. Fogel on behalf of the applicant and Mr. Fallon on behalf of Massdep. That is a provision in the adjudicatory proceeding rules. It's a valid provision that parties in an appeal may rely on in believing that the submittals are not sufficient. Yes, Mr. Fallon.
Thank you, Officer Giolendino. I did reference this out to the other parties. I have a previously scheduled vacation on May 18th.
That's correct. My apologies. I know you mentioned that to Ms. Kearney, and I'm sorry I forgot that. But yes. Do you have a new hearing date? Because I would like to have a hearing date established. I don't want it to basically, yes, Mr. Fogel.
Did you set a date for the petitioner's rebuttal?
Yes, it was May 11th.
Sorry, for some reason these dates aren't set. Thank you.
Yeah, sure, no problem. Do you folks have another proposed hearing date?
I sent out dates. I think people responded that either May 24, 25, or 26.
Okay, say that again, May 24th,
24.
May 25, and May 26th?
Yes.
Okay, so what I will do, I'll look at my calendar, and you saying that all three of you have agreed on those three dates, alternative dates?
I'm not sure everyone responded. Are they good for all parties?
Yeah, Mr. Fogel.
So I remember, after Mr. Fallon sent that out, an email was sent by Ms. Miller saying the 25th, 20th, but that the Tuesdays of those dates didn't work. So the May 25th were less preferable, I guess. I don't know, maybe Mr. O'Brien.
Yeah.
Is that still the
Yeah.
issue?
What's the petitioner's, the residence group's position on any of those three dates?
Yeah, the Tuesdays aren't the best, but we can make it work. We'd rather not do Tuesdays because that's when we have our own internal
Right.
meeting.
All right, so let me just check. It's we're talking Tuesday the 24th that you would not prefer. I mean, you would not want to go with. Let me just check real quickly. All right, why don't we do it for Thursday, May 26th? Okay, and if there is that also raises in-person versus Zoom. And what I have been doing lately is that if it is possible to hold an in-person hearing in Mass DEP's Winter Street office, we'll do it in person. If it's not possible, then I leave it to the parties to decide whether or not we do it via Zoom or postpone it to another date for the possibility for an in-person, or submit it on the record. I can tell you everyone has not opted for submitting it on the record. They want to go forward. So, but it's reasonable for me to, propose all those options. So my post pre-hearing conference report and order will say it will be, the hearing, if it goes forward, will be on Thursday, May 26th, beginning at 9:30. And if it's possible to do it in person at Winter Street, we'll do it in person. If not, then I give the options like I just outlined. Does everybody understand that? Everyone on board, Mr. O'Brien?
Yeah, that's totally fine. Thank you.
Mr. Fogel and Mr. Fallon, I take it that's fine by you? We're just
Sounds
going
great.
by past practice. It's nothing new.
Thank you.
Sure. Now, Mr. Hopper, I don't want you to think I've ignored you as the Deputy General Counsel for Litigation. Do you have anything to add?
I do not, but thank you for offering.
Sure. Welcome. And I hope you found this informative. Sure. Mr. Hopper joined the department, was it September? Last September?
Yes, September 20th.
Yes, and I think it's reasonable to say that he's had the full gamut of administrative appeals in that short period of time. So, but welcome again.
Thank you.
Absolutely. So I believe I have done what I set out to do in this pre-hearing conference. Mr. Fogel, there was something you wanted Mr. O'Brien to follow up with you, and I believe it's a contact information.
No, it was if he intends to reach out to talk about settlement to do.
Yeah, that's what
that was it, though.
But I thought you mentioned about wanting contact information before that. Okay.
Yeah.
I may have I didn't hear you correctly.
I just wanted him to make contact on that before he filed the updated filing on Friday.
Yep. Okay. That's what I'm getting it mixed up with. And on that, Mr. O'Brien, just to repeat that I did accept the group's pre-hearing memorandum today, even though it was filed late and even though it wasn't signed by anyone. But it has to be, I have to have a signed document by this Friday.
Yeah, we take that very seriously, and thank you for the consideration.
And that goes for every other document that the group files in the case. And like with the other documents that the group has filed in the appeal, of course, they have to be also sent by email to all the other persons listed in the service list. That includes Mr. Fogel for the applicant, Mr. Fallon for the department, and all the other individuals, which the group has done thus far. I don't have any questions or qualms regarding that, but it's important, and I don't want to sound like broken record. Important to have signed documents filed, and important that if a deadline's coming up and can't be met, to ask for an extension of time. And before you ask me for extension of time, reach out to Mr. Fogel and Mr. Fallon, because I would prefer on those things that, the parties are in agreement as opposed to there being a dissent. Not to say that there aren't disagreements at times, but you know what I'm saying, all right? So unless there's anything else that the parties want to discuss with me, I am inclined to basically conclude the pre-hearing conference. I want to thank Mr. Jordan Marks from CCCS, our Spanish interpreter, who was here today, who has simultaneously translated everything that has been said at this pre-hearing into Spanish for residents of the East Boston community who have English isolation or limited English proficiency concerns. And if this matter goes to a hearing in May, we will also have a Spanish interpreter at that time as well. And I want to confirm, Mr. O'Brien, that the group wants a Spanish interpreter, because I'm assuming that's what the group today. Thus far, there has been a Spanish interpreter for the SOC that was translated for my scheduling order and for today. Am I right to state that the group will be looking for a Spanish interpreter to be present?
Yeah, it's very important, and we appreciate that accommodation.
So it'll be in person or via Zoom or whatever, however the hearing, if it goes forward, will happen. So I'll make a note of for the hearing. But I think I'm concluded here. Everyone agree?
One quick question.
Yes, absolutely.
I see on that it says live on YouTube and it says copy the streaming link. So if others wanted to watch that, is there a way for people to watch this proceeding on YouTube later?
I will let Mr. Ferson, who knows everything about YouTube and DEP, to speak to that issue.
You're too kind, Officer Giordano. In the past, Mr. Fogel, it takes a little while for that to occur, but it will be available on the Mass DEP YouTube page.
So, Mr. O'Brien, with respect to that, that means that anybody in the group or interested in this proceeding that wasn't able to participate, not view this at this time, this morning, this proceeding, that they can go to the DEP website, look for the YouTube section, and they can view what has transpired today in the YouTube recording. If I said that correct, Mr. Ferson, did I butcher anything in the process?
Oh, no, it'll be there along with all the other YouTube hits.
And there is, like Mr. Ferson said, there's a time lag. So if it takes a business day for it to happen, it's just because of the technology and the timing and the posting. It is a process which I thank Mr. Ferson, and I also thank Paul Locke, who is our interim deputy commissioner for policy, to have assisted us in that endeavor. And this is the second time he's done so. He did it for the PRE oral argument hearing that we had in October. So, which was, I heard lots of positive reviews, including from my kids who got to see me on TV. So, but in any event, in all seriousness, Mr. Fogel, do you have a question?
I was just saying thank you for that clarification.
Sure, absolutely. I think we're done. And so unless there's anything else you want to bring up, I am planning to basically end the meeting. Are we all in agreement to conclude?
Yes.
Thank you. Thank you for your attendance this morning, and thank you for your candid positions. And we'll see where this goes. All right. Thank you. Take care.
Thank you. Appreciate it.
Yeah. Take care, everyone.